Wait, before you scroll past this video, let me ask you something. Are you married? Planning to get married? Or maybe going through a rough patch in your relationship? Then you need to stop right now and pay attention, because what I'm about to share with you could literally save you thousands of dollars and protect your future. The marriage and divorce laws in the United States have changed dramatically, and if you don't know about these updates, you could be putting yourself at serious risk.
I'm not trying to scare you. I'm trying to help you. So give me just a few minutes of your time, and I promise you'll walk away with information that could change everything.
Hello everyone, and welcome back to the channel. Today we're diving deep into one of the most important topics that affects millions of Americans, the latest updates in marriage and divorce laws in the United States. Whether you're a husband or a wife, whether you've been married for decades or just tied the knot, these changes impact you directly. We're going to cover property rights, custody laws, financial responsibilities, and everything in between. I've done extensive research to bring you the most current and accurate information, and I'm going to break it all down in simple, easy-to-understand language. So make sure you hit that subscribe button and turn on notifications, because you don't want to miss any of our legal guides and updates. Let's get started. The landscape of marriage and divorce law in America has transformed significantly over the past few years, and understanding these changes is absolutely essential for protecting your rights and your assets. Let me walk you through everything you need to know, starting with the foundation of marital law, property rights. When it comes to property in marriage, the United States operates under two distinct systems, and which one applies to you depends entirely on where you live. 9 states follow community property laws. These are California, Texas, Arizona, Nevada, New Mexico, Washington, Idaho, Louisiana, and Wisconsin. In these states, almost everything you acquire during your marriage is considered jointly owned by both spouses equally. Your salary, the house you buy, the car you purchase, even the debts you accumulate, they all belong to both of you 50-50, regardless of whose name appears on the paperwork. The remaining 41 states follow what's called common law property systems. Here, ownership belongs to whoever's name is on the title or whoever earned the money to buy the asset. This might sound simpler, but it can actually create more complications during a divorce because you have to trace and prove who owns what. Now, here's where things get really interesting, and this is a major update. Digital assets have become a huge part of our lives and our wealth. We're talking about cryptocurrency holdings, NFT collections, online businesses, digital investment portfolios, and even social media accounts that generate income. Courts across the country are now explicitly recognizing these as marital property that must be disclosed and divided during divorce proceedings. Just last year, several high-profile cases involved spouses who tried to hide cryptocurrency assets, and when they were discovered, those individuals faced serious legal consequences, including penalties and reduced settlement shares. Let's talk about the fundamental rights and responsibilities that come with marriage. In every single state, both spouses have completely equal rights to make decisions about household matters, children, education, and major financial choices. This represents a massive shift from historical practices, where husbands often had final say in family decisions. Today, both partners stand on equal legal footing. However, there are important nuances you need to understand. When it comes to medical decisions, your spouse is generally your default healthcare decision maker if you become incapacitated, but advance directives and healthcare proxies can override this. For financial matters, both spouses can access joint bank accounts and make decisions about joint property, but individual accounts remain separate unless specifically designated otherwise.
This is why financial transparency in marriage is so important.
One of the most significant updates involves prenuptial and postnuptial agreements. These documents have become increasingly common, and courts are taking them very seriously, but they're also scrutinizing them much more carefully than before. For a prenuptial agreement to hold up in court today, several conditions must be met absolutely. Both parties must provide complete and honest disclosure of all their assets and debts. The agreement must be fundamentally fair and reasonable, not grossly one-sided. Both parties must have had a real opportunity to consult with their own independent attorneys. And crucially, the agreement must be signed well in advance of the wedding, not under pressure or duress. The old practice of surprising your fiancé with a prenup just days before the wedding is now frequently challenged successfully in court. Judges recognize that such timing creates inherent coercion. Most legal experts now recommend signing prenups at least 30 days before the wedding, though 60 or 90 days is even better.
Postnuptial agreements, which are signed after you're already married, have gained tremendous ground in recent years. Couples are using these to clarify financial arrangements during marriage to address changed circumstances like an inheritance or business success, or even to strengthen their marriage by removing financial uncertainties. These agreements face even stricter scrutiny than prenups because spouses owe each other fiduciary duties, meaning they must act in each other's best interests. Courts will examine these agreements very carefully to ensure neither spouse took advantage of the other. Now let's address the topic that many people find most stressful: divorce. The divorce laws in America have undergone revolutionary changes. Every single state now offers no-fault divorce, meaning you don't have to prove your spouse did something wrong to end your marriage. You can simply state that you have irreconcilable differences or that the marriage has broken down irretrievably. This has made divorce more accessible and generally less hostile, though the emotional and practical challenges remain significant. Alimony, also called spousal support or maintenance, has been reformed dramatically in many states. The historical model of permanent lifetime alimony is rapidly disappearing. Instead, states are moving toward rehabilitative or temporary support designed to help the lower-earning spouse get back on their feet, complete education, or develop career skills. Many states now use mathematical formulas to calculate alimony based on factors like marriage length, income differences, earning capacity, age, and health. Some states have eliminated permanent alimony entirely, except in cases of very long marriages, typically over 20 years, or when one spouse has disabilities that prevent them from becoming self-supporting. This shift reflects changing societal norms. With more dual-income households and greater career opportunities for women, courts recognize that most people can achieve financial independence with temporary support, rather than requiring indefinite payments. Child custody laws represent perhaps the most dramatic transformation in family law. The outdated presumption that mothers should automatically be primary caregivers has been completely eliminated. Courts now apply gender-neutral standards focused solely on the best interests of the child. Fathers have equal custody rights, and joint custody arrangements where children spend substantial time with both parents have become the norm rather than the exception. Many states now presume that shared parenting is in the child's best interest unless evidence clearly suggests otherwise. What does best interest of the child actually mean? Courts consider factors like each parent's ability to provide a stable home environment, the child's relationship with each parent's mental and physical health, any history of domestic violence or substance abuse,
the child's preferences if they're old enough to express them maturely, and each parent's willingness to encourage a relationship with the other parent. That last factor is crucial.
Courts strongly disfavor parents who try to alienate children from the other parent.
Child support calculations have become more standardized but also more nuanced. Most states use income shares models that consider both parents' incomes, the number of children, and the amount of time children spend with each parent. Recent updates account for modern expenses like healthcare costs, childcare expenses necessary for work, educational needs, including private school or special education, and extracurricular activities.
Some states have reformed their guidelines to reduce support obligations when parents share parenting time nearly equally, recognizing that both households are directly supporting the children.
Technology has also forced updates to custody arrangements. Courts now address issues like appropriate screen time limits, social media usage and privacy, whether parents can post photos of children online, sharing passwords and digital monitoring, and virtual visitation rights for long-distance parenting. Some custody agreements now include specific provisions prohibiting parents from posting negative comments about each other on social media or sharing details about the divorce or custody battle online.
Property division during divorce has become increasingly sophisticated. When dividing marital assets, courts now consider a much wider range of property types. Professional degrees, licenses, and certifications earned during marriage may be considered marital property in some jurisdictions, valued based on increased earning capacity. Business goodwill and the value of professional practices must be appraised and divided.
Retirement accounts, pensions, and stock options are divided through qualified domestic relations orders. Some states even consider pet custody as a welfare issue rather than a simple property division, allowing judges to award custody based on the animal's best interests and the bond with each spouse. Debt division has also been clarified significantly. Generally, debts incurred during marriage are marital debts subject to division regardless of whose name appears on the account. However, courts consider whether the debt benefited the marriage, whether one spouse incurred debt secretly or fraudulently, and whether debt was incurred in anticipation of divorce. For example, if one spouse runs up credit card debt on a gambling habit without the other spouse's knowledge, a court might assign that debt entirely to the spouse who created it. Same-sex marriage has been federally protected since the Supreme Court's decision in 2015, and subsequent legal developments have clarified that same-sex couples have absolutely identical rights and responsibilities as opposite-sex couples in all aspects of marriage and divorce. This includes property division, custody rights, adoption rights, spousal benefits, tax treatment, and immigration benefits. Any discrimination based on sexual orientation in family law matters is prohibited. Domestic violence protections have been dramatically strengthened across the country. Every state now has expedited processes for obtaining protective orders, often available within 24 hours. Courts must consider any history of domestic violence when making custody decisions, and such history can result in supervised visitation or denial of custody. Immigration protections exist under the Violence Against Women Act for abuse victims married to U.S. citizens or permanent residents, allowing them to self-petition for legal status. Financial abuse, which includes controlling access to money, preventing a spouse from working, or destroying their credit, is increasingly recognized as domestic violence and can be addressed in divorce proceedings.
Several emerging issues continue to shape family law. Courts are wrestling with how to handle frozen embryos created during marriage when couples divorce, with different states taking vastly different approaches. Social media evidence has become standard in divorce cases, with posts, messages, photos, and online activities regularly used to demonstrate income, lifestyle, parenting ability, or infidelity. Cohabitation clauses in alimony agreements are being refined to address situations where ex-spouses live with new partners. Virtual visitation rights using video calls and messaging apps are being incorporated into custody orders, especially important for military families and long-distance situations.
For anyone facing divorce or marital difficulties, documentation is absolutely critical. Keep meticulous records of all income sources, assets, and expenses. Document your involvement in your children's lives through calendars, photographs, school communications, and medical appointment records. Save important communications with your spouse, but avoid excessive contact or anything that could be construed as harassment. Protect your digital security by changing passwords and monitoring accounts. Most importantly, seek legal advice early to understand your specific rights and obligations under your state's laws. And there you have it, a complete breakdown of the major updates in United States marriage and divorce laws and the rights that protect both husbands and wives. These changes represent a massive shift toward fairness, equality, and recognition of how modern families actually function. The law is moving away from outdated gender stereotypes and toward protecting both spouses equally while prioritizing children's well-being above all else. But here's what you absolutely must remember. While I've given you a comprehensive overview of general principles that apply across the United States, the specific laws in your state might be different. Family law varies significantly from one state to another, so if you're dealing with marriage issues, divorce, custody battles, or property disputes, you need to consult with a qualified family law attorney in your jurisdiction. They can give you advice tailored to your specific situation and ensure your rights are fully protected. The legal landscape continues to evolve constantly. New court decisions, legislative changes, and societal shifts mean that staying informed is your best defense and your greatest asset. Knowledge truly is power, especially when it comes to protecting your family, your finances, and your future. If you found this video valuable, please smash that like button and share it with anyone who might benefit from this information. A spouse going through a tough time, a friend considering marriage, or a family member dealing with divorce, this information could make a real difference in their lives. Subscribe to the channel and hit the notification bell so you never miss our legal guides, updates, and practical advice. Drop a comment below if you have questions, personal experiences you'd like to share, or specific legal topics you want me to cover in future videos. I read every single comment, and I love hearing from you. Thank you so much for watching and for trusting me to guide you through these complex legal issues. Remember, you're not alone in this journey, and understanding your rights is the first step toward protecting yourself and your loved ones. Take care of yourselves, take care of each other, and I'll see you in the next video. Until then, stay informed and stay empowered.